It is 8:38. We'll have this meeting come to order. Kay, if you mind calling roll, please.
Mike Harris-Mendez.
Present.
Tom Butler.
Here.
Kelly Collier.
Here.
Rick Figueroa.
Here.
Catherine Oswald is absent today. Bobby Shaw is absent today. Deborah Yurko is absent today.
Commissioners, it's customary for us to excuse the absences of the three commissioners, but I think in light of the fact that we made it here and they didn't. No, I'll entertain a motion to excuse the absences.
So moved. Second.
We have a motion, second, all in favor?
Aye.
Those opposed, motion carries. We'll now enter into executive session, consultation with attorneys on section 5510711 of the Government Code to receive a briefing on pending or contemplated litigation and/or settlement offers. Also advice from the Commissioner's attorney on legal matters as authorized by 5510712 and under section 5510774 of the Government Code, discussion of personnel matters. The commission will come back in order. Let's go on to item D, action on any items discussed in executive session. Commissioners, is there any motion for anything out of executive session? Hearing none, let's go on to item E, approval of minutes. You've had the opportunity to review the minutes that have been brought before you. Any changes or a motion to approve?
I move that we accept the minutes.
Second.
A motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. F1, contested cases. Michael Dean. Is Michael Dean here, or anyone here representing Michael Dean? Proceed, Mr. Medlock.
Good morning, Commissioners. My name is John Medlock, and I'm prosecutor for the Enforcement Division and represented the department at the SOA hearing on October 11, 2016. On September 22nd, 2014, Michael Dean offered to perform electrical work by posting a Craigslist advertisement where, among other services listed, Mr. Dean listed that he was available to perform electrical work. The department found this advertisement and conducted a mini-sting where Mr. Dean was contacted by the department investigator via text message and asked if he could perform electrical work. Mr. Dean responded that he could perform the work and quoted a price. The department charged Mr. Dean with offering to perform without having the required license. The ALJ concluded the evidence presented established that the respondent had offered to perform electrical work in violation of the statute. The ALJ assessed a penalty of $500, and I would recommend that you adopt the PFD as presented. I'm available to answer any questions.
So even though we sought a $2,000 penalty, you guys are okay with $500?
Yes.
Okay. Commissioners, questions or a motion?
I move that we accept the PFD as written.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir. Let's go on to item F2, Vicente Castellanos. Mr. Castellanos here, or anybody representing him? Mr. Sharp. Let's move on. Let's go on to item number 3. Wait for Mr. Sharp to come in. David Jackson. Is anyone here for Mr. Jackson or Mr. Jackson himself? Mr. Rennick.
Chairman, Commissioners, Robert Rennick from the Enforcement Division. Mr. Jackson seeks an apprentice electrician license. Between 1995 and 2015, he was convicted of 10 crimes, 4 of which were felonies. He was convicted of unlawfully carrying a weapon, possession of a firearm by a felony, criminal trespass twice, possession of a controlled substance 3 times, all of those felonies, possession of marijuana twice, and organized retail theft. Since 2007, the applicant has gone to prison about every 2 to 3 years. The 2 crimes most related to the electrician occupation were committed within the last 5 years. In 2012, the applicant was convicted of organized retail theft when he and others drove a trailer and a pickup truck to a Home Depot after hours. They stole over $5,000 worth of shingles from a fenced area. Then in 2015, the applicant and 2 others attempted to steal copper and other metal off the roof of an abandoned building. The applicant was convicted of criminal trespass out of that incident. In March of 2015, soon after that conviction for criminal trespass, the applicant was sent back to prison until his release in July of 2015. A month later, approximately, a little less than that actually, he filed this application that's before you today. When his application was submitted to the department, it said that he had not been convicted of any felonies or misdemeanors, which of course he has. The applicant knew that the answer to the criminal history question was false. He later told one of the investigators of the department that he did not correct the criminal history answer because he was concerned that the correct answer would keep him from getting a license. He was born in 1975. He was approximately 20 when he committed his first crime and approximately 35 when he committed his last. The ALJ recommends that the Commission deny the application because of the number of crimes committed by the applicant, because 2 of his recent crimes were directly related to the occupation, especially the attempted theft of metal, and because the applicant falsified his application. The Department recommends that the Commission adopt the PFD.
Any questions for Mr. Rennick? Motion be in order.
So moved.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 4, Jesus Salinas. Mr. Foster.
Good morning, Chairman.
How are you?
I'm doing fine. How about yourself?
Good.
I am Ron Foster, a senior prosecutor with the Department's Enforcement Division. I will be presenting this case against Mr. Jesus Salinas. Mr. Salinas is currently licensed, actually registered as a property tax consultant. He's doing business as property tax experts in El Paso. Mr. Salinas was first registered with the department as a property tax consultant in 2004. He renewed his registration in 2005, but he allowed it to expire in 2006. The department previously issued a default order against Mr. Salinas in October 2009, which assessed a penalty of $2,000. This was for providing property tax consultant services without a registration in 2008. Now, based upon the evidence, the ALJ found that Mr. Salinas continued to perform property tax consulting services for compensation, although his registration was expired, and he did so even after the issuance of the prior order in 2009, as he did not again register with the department until June of 2014, after the department had initiated the investigation of this case currently before you. Mr. Salinas was not a registered property tax consultant for nearly 8 years and even had an order issued against him. However, that did not deter him from providing property tax consultant services for hundreds of clients on thousands of accounts valued at millions of dollars. His clients were not just homeowners, but large companies as well, including restaurants and radio and television broadcasters, all at a time when he knew he should be registered. At the time this matter was set for hearing at SOA, Mr. Salinas was also delinquent in making the required payments on the previously issued order of $2,000. He had only paid $200 towards that penalty. However, as of January 5th, 2017, Mr. Salinas has now paid in full that $2,000 penalty. Now, the ALJ recommends a penalty of $15,000 and a 1-year probated suspension of property tax consultant number 3774, based upon respondent's testimony regarding his financial and medical circumstances. I believe those statements are consistent with the email that you should have been given regarding this case today. The department does agree that ALJ's recommendation is reasonable based upon the circumstances and the factors to be considered set forth in the enforcement plan. The department recommends the commission accept this PFD.
Any questions for Mr. Foster? Is anyone here representing Mr. Salinas? A motion be in order? So we have a motion and a second. All in favor signify by saying aye. Aye. Those opposed, motion carries. Thank you, sir. Let's go back up to item number 2. Vicente Castellanos. Mr. Sharp.
Morning, Mr. Chairman.
Morning.
Apologize for being late. I was upstairs trying to get some work done.
We're efficient.
No, I wish I was fishing, but...
No, we are efficient.
Oh, you're efficient. Oh,
Yeah, I'm not concerned about you. I'm telling you, we're efficient.
I'm efficient at fishing. Anyway, I'm sorry I was late. In
worry
fact,
about
I
it.
hope as long as I'm alive, that's the only time I hear anything about the late Ken Sharp.
Yeah.
Okay. Anyway, my name is Ken Sharp. I'm with the Department of Licensing and Regulation in the Enforcement Division. The applicant in this case is Vicente Castellanos, Jr. Mr. Castellanos applied for an apprentice electrician license on January 26th of 2016. Excuse me. The department proposed a denial of his application because of his criminal history and because the applicant did not demonstrate that he has the requisite honesty, integrity, and trustworthiness. In fact, the evidence shows that he does not possess these qualities. In May of 2014, the applicant was placed on deferred adjudication community supervision for a period of 5 years for burglary of a habitation. It was in February of 2014 that the applicant and a young woman friend of his had broken into a house with the intent to steal televisions. The police received a report about the break-in, and so they responded. And when they did, they interrupted the burglary, and they arrested the applicant and his friend inside the house. At that time, the only thing the applicant had taken was an MP3 player. Now, the applicant was 17 years old at that. He was almost 18, but he was 17 years old at that time when he committed the burglary, and he was 19 years old when he applied for the license. He gave several different accounts of the circumstances of the burglary. Initially, he told the police he had received some directions from some person by text message to commit the burglary, and he got instructions on how to get in and what to steal. Eventually, after the police questioned him some more, he admitted that he and another person had planned the burglary, but the other man became unable or unwilling to participate at the last minute. On the criminal history questionnaire submitted with his application, the applicant wrote that he and a friend broke into the house because they had nowhere else to go. Now, notably, during the hearing, the applicant testified that he was already performing electrical work as an electrical apprentice, even though he did not have a license. The ALJ refused to consider the applicant's disregard of the electrician licensing law, however, even though it is, as the statute puts it, other information that indicates the applicant lacks honesty, trustworthiness, and integrity, which character traits the applicant is required to demonstrate. And also, the ALJ failed to consider the several different versions of the incident that the applicant gave to the police and to the department and then in his testimony. And finally, the ALJ said the applicant would only have a limited opportunity to repeat the offense of burglary while on the job because he would be supervised, but that's not the correct standard under the statute. Well, despite the evidence and the Commission's criminal conviction guidelines, the ALJ recommended that you grant the applicant an apprentice electrician license. But because the applicant has not yet demonstrated the requisite honesty, integrity, and trustworthiness, and in fact shows that he lacks those characteristics, the Department recommends that you revise the findings of fact and conclusions of law consistent with the Department's exception to the PFD and deny the application at this time. Thank you.
Any questions, Mr. Sharp?
I have a question.
Yes.
How old is Mr. Castellano now?
Well, I'd have to do some math.
17 in 2014, so,
19 now?
right. That's when the
He
offense
was.
occurred.
I was
Yeah.
going to look at months
So-
and things like that. So, so if you add 3, I guess he could be 20, maybe 21, depending on the months.
He applied for his license on what day?
That was on January 26th of 2016.
And he's still on probation.
Yes.
Make a motion that we deny the PFD based on finding of fact number 10. For the SOA judge finds that he is trustworthy, honest, and has integrity to hold the license.
We have a motion.
Mr. Chairman, this is Brad
Dickerson.
Bowman, General Counsel. I would, if I could just
I was waiting to hear from you,
interject
Brad.
a couple of
Hi, Brad.
suggestions there.
You can speak into the mic, Brad.
Findings of fact 11 and also conclusion of law 9, I think, go to the judge's conclusions. And another point is, in order to change the PFD, you have to find that the judge misapplied the law, and in this case, that would be the factors, the statutory factors the commission has to consider in granting a license. So maybe some statement as to that, why you think that is the case.
You say finding of fact number 11, Brad?
Conclusions of law 9.
And conclusion of law.
In conclusion of law number 9, correct.
Did I say Fred? I thought I said Brad.
Just
Okay.
change his name.
Would you help me with the wording of that, Brad?
To modify the PFD.
Well, let's see. The finding of fact number 11 is the evidence was sufficient to show Mr. Castellanos currently possesses the fitness required to perform the duties, et cetera. And so it sounds like you're wanting to change that to say does not currently possess the fitness.
Correct. And there hasn't been enough time, and his age, and so I say that we deny the PFD. I recommend that we deny the PFD and deny Mr. Castellano his license.
So we have a motion on the floor.
A second.
Second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. Thank you, sir. Let's move on to G1, the motions for rehearing. Lacey Bishop. Who's coming up? Della? Ms. Lindquist, my apologies. Is anyone here representing Lacey Bishop or Casabella? Proceed.
Hi, good morning.
Morning.
Aye.
Della Lindquist, Deputy General Counsel. In this first matter, Ms. Bishop had attempted to settle this matter with the department early in the case and didn't follow through. However, she indicated she wanted to pursue that settlement amount, and the department indicated they would not be opposed to you granting this motion for rehearing in order for them to sign an agreed order with her. She has paid the $250.
She has?
Mhm.
Okay.
So we recommend granting, and then that would allow the Enforcement Division to sign an agreed order with her.
Okay. We have a recommendation from General Counsel to grant the motion for hearing to allow for the settlement offer.
So moved.
We have a motion, second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 2,
It is-
Shiny Nails.
In the second case, the respondent alleges, and there is some indication that there is some discrepancy in who the actual owner of the shop was, and it might have been difficult at the time the Enforcement Division was attempting to discover this, and some other, I don't want to call it evidence, some other information has come to light that might shed light on the true owner. Therefore, in the interest of justice, we don't see any error, but in the interest of justice, we would recommend granting the motion for a hearing so that the Enforcement Division can establish the true owner at the time of the violation.
Okay.
Make a motion for so moved to grant a hearing.
Second.
We have a motion, a second. I failed to ask, is anyone here representing Shiny Nails Municipal? We have a motion, a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 3 for Tri-County Towing.
Thank you, Commissioners. Doug Jennings, Assistant General Counsel for the Department. In this first matter, Camille Herron, it resulted from a default order in which the Commission assessed administrative penalties against the respondent totaling $2,000 based on the respondent's failure to ensure that a towing operator employed by the company had undergone annual drug testing. In the motion for rehearing, the respondent alleged that the employee had in fact completed drug testing, and in some correspondence with the Office of General Counsel, scanned what appear to be receipts. It's not terribly clear. The quality on one is quite bad, and the other is just an internet printout. And General Counsel just isn't in the position to verify the authenticity of those types of documents. There was no indication that there was no error of law here. There was never any indication that the notice of the default or the notice of violation wasn't received by the respondent. And this is the kind of matter that is best dealt with in a hearing, which the respondent didn't request. And so we are recommending denying this motion.
Is anyone here representing Tri-County Towing? A motion will be in order, Commissioners.
So moved.
We have a motion to deny the motion for rehearing. Second? I'll go ahead and second it.
Can I ask a question real
Yeah,
quick?
sure.
So, did you tell them that the evidence wasn't enough, or, I mean, did they respond to you at all?
To be honest, I never spoke with the respondent personally. I know our staff had some discussion.
Okay.
And in fact, we were told by the respondent that she would be here today to discuss that with you, but
It seems like such a minimal thing to address, and
it does, and, you know, there is a possibility, of course, that maybe if there had been some discussion, someone would have been satisfied that these were authentic documents, but as far as I can tell, there wasn't enough of it back and forth. And honestly, since, you know, the posture of this case before you is from a default in which the respondent never requested a hearing, you know, going into those things, that's really what the administrative procedure is about.
And she
you
had
know,
the
to
ample
determine
opportunity
those
to
issues.
be able to present this information prior to.
Correct.
She just failed to do it.
Correct.
So-
Had every opportunity to request a hearing or at least, you know, try to maybe work with the department in some alternative way.
But it wasn't until we got to this step that she decided to present this material.
That's my understanding, yes.
Okay.
and she's not here today.
She's not here today, so.
Okay.
Any further questions? We have a motion on the floor. All in favor signify by saying aye.
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 Those opposed, motion carries. Item number 4.
Was it seconded? You did?
Yeah, I seconded it. No one would speak up, so I had to second it. Item number 4, Paradise Towing and Records. Anyone here for Paradise Towing? Let's go ahead.
All right, thank you. It's similar type of issue in this case. Also resulted from a default order in which the commission assessed administrative penalties of $3,200 based on respondents' alleged improper non-consent tow from a parking lot that lacked legally required signs. And additionally, a failure to issue a vehicle owner an adequate notice of rights. In this case, in the motion for rehearing, the respondent alleged that the parking lot did in fact have the legally required signs posted in it and attached a photo, undated, of the parking lot in question, which appeared to have, if you zoom in really far, you can see some signs. But once again, we have no indication of when this photo was taken, if it was after the fact. There's no indication here that the respondent didn't receive the notice of violation. The respondent did not request a hearing. And once again, these are the kinds of issues that the hearing process is designed to address. The authenticity of the photograph when it was taken, if it reflected the state of the parking lot on the date of violation. And our office is not in the position to be able to make that determination. And so finding no error, we again would recommend denying this motion.
We have a recommendation to deny.
I move
Motion
that-
be in order.
Right, I move that we deny.
We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 5, Phoenix Towing. Anyone here for Phoenix Towing? Proceed.
Thank you. This matter resulted from a default order in which the commission assessed administrative penalties against the respondents totaling $6,000 based on their alleged employment of an unlicensed person and for improperly conducting 2 non-consent tows. Now, in this case, there were 2 respondents, Robert Garcia and Ruth Belmonte. And I believe they were co-owners of a business called Master Towing. When the violations in place, the alleged violations took place, they co-owned Master Towing. We received a motion for rehearing from one of the respondents, Robert Garcia, who said, I no longer own Master Towing. It's no longer a business. Phoenix Towing is the new business that Ruth Belmonte owns. And if you look through our notice of violation that enforcement sent out, you will see that it makes allegations that both respondents are co-owners of Phoenix Towing, this new entity. And we just feel that that isn't a correct summary of the facts. In this case, the alleged violations took place while the co-owners while they owned a business called Master Towing. The NOAV says the violations were committed by Phoenix Towing. And so we see that there's just some factual inaccuracies that we think could be ironed out in issuing a further NOAV. And so we would really recommend granting this motion for rehearing so we can go through the NOAV process, correctly identify the businesses as they were, we identify Master Towing and make sure we don't have this confusion about Phoenix Towing since one of the respondents doesn't own that business.
But the violations that you show occurred under Master Towing.
They did, that's correct.
But we're showing Phoenix Towing, which one of them doesn't even own.
Right.
He never owned.
We think
All
they
right.
own it.
Right.
Well,
We think they both own Phoenix Towing now.
well, right now the motion for rehearing says that Mr. Garcia does not own part of Phoenix Towing.
And he showed documented proof of that based on what he's given
Well,
us. Or
once
assumed
again,
name
he showed
certificate.
an assumed name certificate, which appears to indicate that. But that's not really our primary concern, to be
Right.
honest. To me, I just want to make sure that we are identifying with some accuracy the name of the business that these violations were committed by, just so we can have a clear idea. I think maybe if we had stated it in the NOAV, the respondents were previously operating Master Towing, and maybe not
Yeah,
even
clear it
resolve
up.
the issue of who owns Phoenix
We'll
Towing.
clean it up a little bit.
We
Okay.
would be more comfortable with that.
Sure.
Okay.
Yep. Well, I move that we grant a rehearing.
We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you.
Thank you.
Let's move on to item H. I'm not
I-
sure who's presenting.
I will stay here.
Oh, you're gonna sit,
Yes.
okay.
Thanks again, Doug Jennings.
This is a discussion possible action on the rules for administrative services to implement Senate Bill 20. Go ahead.
Yes, thank you. Thank you, Chairman. These rules are additions to Chapter 55 of TDLR's existing rules. There will be an amendment of a couple of existing rules and an addition of 2 new rules. As the chairman said, one of the new rules is to bring the department into compliance with Senate Bill 20 from the previous session. Another is to bring the department into compliance with an older statute from the government code. As you will see, the amendments to sections 55.1 and 55.10 are fairly minor. The amendment to 55.1 is a house cleaning, is really a house cleaning change. Just adds some additional chapters of the government code as our authority for this chapter of the rules. In the definitions, 5510, we just add definitions for Financial Services Division and then the director of that division. One of the new rules, proposed rule 55.100, deals with contract monitoring responsibilities and is adoption of this rule will bring us into compliance with government code section 2261.202. And that statute just requires our agency to adopt a rule clarifying and explaining which of our staff is in charge of contract monitoring and auditing of certain contracts. And this rule does that. It will bring us into compliance. A little more interesting is proposed rule 55.101, which deals with enhanced contract monitoring. Now, adopting this rule will bring us into compliance with Senate Bill 20, which was, of course, is a package of statutes designed to bring more transparency to the agency contracting process. And the rule states in subsection B that for each contract entered into by the department, our staff will look at the contract and determine if enhanced monitoring of the contract or the contractor's performance is required. And C gives a nice litany of factors that our staff will consider when making that determination. And we worked closely with the Financial Services Division, particularly Jerry Daniels and Ashley Davis from that division, in coming up with this list. And subsection D requires our Financial Services Division to report to the Commission on a quarterly basis those contracts that do require enhanced monitoring. And lastly, subsection E is right out of the statute and allows our Financial Services Division Director to come to the Commission directly if he identifies any serious issue or risk with regard to a particular contract that requires enhanced monitoring.
Any questions? I'm sorry.
Sorry, Commissioner. Just wanted to mention that the effective date, we're aiming for an effective date on these of March 1st.
Okay, glad you said that. I completely forgot
When you
about that.
speak of the Financial Services Division, what are you speaking to, Director?
It is our division that deals with making procurements,
Okay.
contracts. I've got a full definition. They deal with accounting, budgeting, contract management, financial reporting, those functions.
Commissioner Figueroa, this is Brian French. You may recall that that's the division that's led by the very effervescent and jubilant Jerry Daniels. He purchased a
Take a bow, Jerry. Take a bow.
personality this year, so 2017 he's a completely different guy.
Thank you, sir. Thank you for that clarification. Right.
So, effective date of March 1, because this says February 15.
Correct. I'm sorry.
Just
I
make sure
believe
March 1.
the deadlines have changed a little bit,
Okay.
and Pauline just informed me that it would
Okay.
be the 1st.
Commissioners, motion be in order, unless you have questions?
So moved.
Second.
We have a motion and a second to adopt the rule effective March 1. All in favor signify by saying aye.
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 Those opposed, motion carries. Item I.
Thank you.
Thank you, sir.
Thank you.
Possible, discussion, possible action on repealing existing rules to the IHB program.
Good morning, Commissioners. My name is Laura Pefferly from the General Counsel's Office.
Morning,
Good
Laura.
morning, Laura.
Good morning. These rules are for the repeal of 70.100 and 70.101 in the Industrialized Housing and Buildings Program. What these rules do is adopt the new mandatory building codes. There are 8 codes: the International Building Code, Residential, Fuel, Gas, Mechanical, Plumbing, Energy Conservation, and existing building codes of 2015. and the National Electrical Code of 2014. Those codes are adopted in 70.100, and then in 70.101 are the amendments to each of those codes to sort of dovetail them into Texas law. The statute requires that if the new code additions are in the public interest and consistent with the purposes of the Occupations Code for industrialized buildings, that the council adopt the new codes. The council did indeed meet on August 22nd and determined that these codes should be adopted. They were proposed and published on November 18th. Comment period closed on December 19th. There was one comment that was irrelevant to the substance of the rules. The council is required to make the rules effective 6 months after they determine that they should be adopted. That's basically to give the industry lead time to implement the new changes. In this case, a lot of localities are already using the new codes, and that process is already going on. The council, when they met, recommended that these be effective June 1st, but they understood that because of the rulemaking process that that deadline might not be made, and in fact it won't be. So we are proposing or recommending that you adopt the proposed repeal of these two sections, 70.100 and 70.101, and adopt the new 70.100 and 70.101 with an effective date of August 1st of this year. And if you have any questions, I'll be glad to answer those.
Any questions for Laura? Motion be in order.
So moved, that we adopt the rules.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, Laura.
Thank you.
Item J, discuss possible action of proposed repeal of the transfer rules as a result of Senate Bill 202. Commissioners, I think the next three will be in relationship to 202. This one has to do with the orthosis and prosthesis program. So, Brad.
Good morning, Mr. Chairman and Commissioners. Brad Bowman, General Counsel. Actually, my remarks will apply to items J through P. So those seven sets of rules.
So
And
what we'll do is, will anything be different on them?
no,
So
sir.
all your statements will go across all of them?
Yes, they are
Okay.
all the part of the same rulemaking effort, and I can explain
Okay. Well,
explain that in a minute.
what we'll do then is, we'll go ahead and let Brad present on this first one, and then we'll take up J, then immediately follow and take up K, and then just do them individually, but you would have already spoken about them all.
Sure.
Okay, sounds great.
So we're not making a motion after,
We'll make a motion after each one.
okay, that's fine.
So this rulemaking is, for each of these items, it's kind of the culmination of the first phase of the transferred programs under Senate Bill 202, the programs that transferred from the Department of State Health Services over to TDLR, those health-related programs. And as you recall, the Commission adopted new rules for all of those programs effective October 1st of 2016, and the Department took over regulating those programs on October 3rd. And so those programs are operating under the new rules that the Commission has adopted. However, there are still the old, now obsolete rules from the Department of State Health Services for each of those programs that DSHS was operating under. And so each of these items is to repeal the old DSHS rules, which are still on the books, and so we need to take care of that. But that's really all that we're doing here, is repealing the obsolete rules because the new rules are now in effect. And so for each of these 7 programs, orthotists and prosthetists, dietitians, athletic trainers, midwives, hearing instrument fitters and dispensers, speech-language pathologists and audiologists, and dyslexia therapists and practitioners. That would be the case. We had to go through the rulemaking process to repeal these rules just like any other rulemaking effort, and we did publish them for public comment. We only received one comment on and that was on the athletic trainers repeal, and it was just questioning what are we talking about with regard to obsolete rules. Hopefully I've explained that, and that I think addresses that comment. So there are no other public comments, and with that, we would recommend that the commission adopt each of these sets of rules with an repeals, with an effective date of March 1st, 2017. And I'm available to answer any questions that you may have.
Any questions for Brad? I think this is kind of the culmination of everything being moved over to us. This should be our final step.
For phase one, that's true.
For phase one, right, but it's just our final step, and we'll be done with them.
Correct.
Or they'll be transferred, be complete, okay.
Yeah.
So let's go ahead and take up item J first, which is the orthosist and the prosthetist program. A motion to be in order?
Yeah.
And this would be to repeal the
Yeah, the
rules,
absolute.
and the transfer rules coming over to us,
Correct.
effective March 1.
Yep.
Motion to be in order?
Second.
Well, let's just do them individually, although Brad's not gonna speak anymore, so he could go and sit down if he needed to. But,
I so move that we,
let's just do the O and P first.
Okay.
So, motion to be in order for O and P.
doing this in aggregate?
Yeah.
I think it's just to be able to have that on record that each individual one was
Okay.
repealed.
Okay.
Just to have it on record. And if you guys would spend more time making motions, we'd be done by now.
I second it. I second it.
Motion in a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item K, which is the dietitians, a motion to be in order.
So moved.
second.
With motion second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item L, which is the athletic trainers.
Move.
We have a
Second.
motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item M, which is the midwives.
So move.
So move to repeal.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item N, which is the hearing instrument fitters and dispensers. Motion be in order.
So moved.
So moved.
We have a
Second.
motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item O, which is the speech language pathologist and audiologist.
So moved to
We have a
repeal.
motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item P, which is the licensed dyslexia therapists and licensed dyslexia
moved.
practitioners. We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Motion carries. Oh, those opposed? Motion carries. All right, that was easy.
Thanks,
Thanks.
Brad.
Thank you, Brad.
We'll now move on to item Q, which is the penalty matrix for the athletic trainers program.
I knew that was coming.
Proceed.
Good morning.
Hi
This-
there.
The infamous Christina Kaiser's now come before us.
We like
Your name is known throughout the land.
Hopefully in a good way.
Your name is known throughout the land.
Good morning,
Feel free to
Mr. Chairman.
audit the chairman anytime you feel you wanted to.
Of course, in a good way.
Good morning, Mr. Chairman, Commissioners. I am Christina Kaiser, the Director of the Enforcement Division here at TDLR. At Agenda Item Q, you have in front of you a draft penalty matrix for the Athletic Trainers Program. This is one of the 7 programs that were transferred to us in Phase 1 of the transfers from DSHS. At the end of our discussion today, I'm going to be asking that you approve this penalty matrix to be included in TDLR's enforcement plan. For the benefit of the newer commissioners who I don't think have ever heard a discussion before about a penalty matrix, I'd like to give you a little bit of background about what it's used for and how we create a penalty matrix. The penalty matrix is used to put the industry as well as the public on notice of the penalties and license sanction that a person is subject to if they commit a violation of, in this case, the athletic trainers statute or rules. So that's the public use of it. It also has a use inside our house. Inside the enforcement division, it serves as guidance for our prosecutors. If the prosecutor decides to issue a notice of alleged violation to charge someone with a violation, the penalty matrix helps them decide what penalty or license sanction to ask for in that NOAV. Generally, the prosecutors are bound by the dollar limits reflected in the penalty matrix. They can go outside it with my permission, but that doesn't happen very often because the whole point of the penalty matrix is to provide that guidance, and it's developed with input from the industry.
I think one of the things that they need to know is that in some of these programs, there was kind of a major undertaking that took place a couple of years ago, maybe, that, and not in this one here, but it's kind of gave us the model of what we use now, of kind of revising, going through there to make it a little bit more applicable to the violation itself, because some of them were way off, and Christina and her
Right.
group did a really good job of bringing that back in and
Right.
kind of tidying it all up together, so.
In the last few years, we have revisited several of the penalty matrices. I can recall doing a lot of work revising several times going around the cosmetology and barber penalty matrices and also the tow truck and VSF penalty matrices. And so that's kind of a foreshadowing, the penalty matrix that you adopt today is not set in stone forever after in time. And, it can be revised as we go along. A couple of things that I want to mention the penalty matrix is not. It does not create more laws that are applicable to athletic trainers. We simply lift the violations that are represented in the statute and the rules for the program and plop them into this format and then organize them according to how serious they are. So if you read something that sounds like, oh, that's a funny thing that an athletic trainer is required to do, that is because it's represented in the statute or the rules. Another thing I want to mention is that the penalty matrix does not represent all possible outcomes that are available in an enforcement case. Or another way to say that is the penalty matrix does not obligate enforcement to pursue a penalty or a license sanction every time we find a violation. We have an array of potential outcomes, both formal and informal, and I can tell you that overall, across all programs, we resolve the majority of cases through informal methods. Some of the informal resolutions are a finding of insufficient evidence to prove a violation. We close the case, we move on. We issue warnings in some cases where violations have been found, if the violations are perhaps less serious or if perhaps they're a first-time violation for the offender. Even when there are more serious violations reflected by the evidence, we can still close those cases informally. In some instances, if the respondent, the person the case has been filed against, takes action to make the consumer whole, because ultimately that's a much better outcome than a penalty being paid to the state. So this is a discussion that I have a lot with the advisory board members in the early days because they see numbers and they get really bound up thinking, oh no, this is a drop the hammer automatic kind of thing, and it most definitely is not. The penalty matrix is not binding on you, the commissioners, when you make your final decisions in contested cases. However, I can say that over time, we have observed that the commission has generally stayed within the limits shown in the penalty matrix, and I think that's just out of deference to the advisory boards who had input into this process. We worked with the enforcement work group from this advisory board to create the document. The members of the enforcement work group are Daryl Gaines and Dr. David Schmidt. The work group met on 2 dates, October 10th and November 14th, and then we exchanged emails afterward to complete the document. We then presented the draft matrix to the full advisory board of athletic trainers on December 12th, and the board voted to recommend that you approve the matrix. I would like to draw your attention to a few elements. Those of you who are more experienced with working with penalty matrices might notice a few differences. You'll see that in the athletic trainers matrix, we only have a single range of penalties reflected for each class of violation. And this is different from our penalty matrices in our more tenured programs, where we have separate ranges set out for first violation, second violation, and third violation. Do you have an example?
Is there a reason for that?
Chris can, I'll talk about that. Chris can show you, this is an example of what I'm talking about. Air conditioning and refrigeration, we have first range, second range, and third. And we're making this recommendation not only for athletic trainers, but for all of the health-related programs for a couple of reasons. First, we just don't expect very much enforcement to happen in the athletic trainer program or in any of the others. the other health-related, at least the first phase of the health-related programs. And so the second and third violation categories would be largely academic and maybe not used hardly ever. For athletic trainers in particular, a single range of penalty makes sense because the athletic trainer statute sets the maximum penalty for anything ever at $500 per violation. So this is unlike most of our programs where we have the range up to $5,000 in Chapter 51 of the Occupations Code. So when you have that broad of a range, you can slice it up a lot more finely, but when you only have $500 to work with, there's not much room to slice things up.
Didn't realize that we had a cap on that.
Yes, sir, in the athletic trainer statute, and I think one or two of the other Phase 1 programs are going to have that as well. Also in athletic trainers, our discussions with the work group helped us learn that there are quite a few violations here that they consider one and done. If you commit this violation once, you should be out of there. You should lose your license. And you'll see those represented in Class D, the highest class in the matrix. It's sort of unusual compared to other programs to have this many violations in Class D.
So that's not a situation where you get a warning in that, or would it be?
Well,
It's one and
we
done.
still have to have evidence that proves the violation.
Okay.
But the advisory board members were pretty clear that if you have evidence of these things, we want the person to lose their license.
Okay.
So, or in the event of unlicensed activity, which is also included in Class D, they want them to have the highest penalty available. Also, there are a lot of those in Class C that have the potential for license revocation if the circumstances warrant. We're learning in this program and in several of the other health-related programs, violations can vary widely in terms of the potential harm that's created. This is different from some of the other programs that we administer where you have a lot of violations that we kind of consider binary. It's either you did it or you didn't, and there's not a lot of wiggle room to explain or to quantify a difference in the harm that's created. But here, the harm can vary broadly from one case to the next. Our recommendation for the single class the single range of penalties for each class is also based just on our experience with penalty matrices in other programs. The separate penalty ranges for first, second, and third have become a source of confusion and a source of debate in some of our existing programs. They are something that the lawyers and the judges argue about and disagree about and stumble over, and they take up time and they take up energy in contested cases that is drawn away from the merits of the case. People have varying opinions about when those first, second, and third ranges should apply, even though we have instructions that state the department's policy position about when those things should apply. Other lawyers, judges, and so on differ from that opinion, and so it becomes an issue. So to avoid that confusion carrying over into enforcement in these new programs, we would like to try this approach of just having a single range of penalty and see if it is a cleaner and more efficient way of resolving cases.
Because based on that confusion, was there enough data from that confusion to say that we can lock it down to make it, three separate, the way that you have it right now? That based on what you're hearing, we can lock and load it and it's down. Or
I'm not sure.
well, I mean, with all the data that you have, you say it's going back and forth. That's data, and so would that give, and I presume the answer is no, since you want to go with the single one.
Yeah, I mean, I think that in athletic trainers, this especially makes sense because of the narrow range of penalties. But
Got it.
it's, especially in the early days when we're learning our way with these new programs, we want anything that we argue about to be focused on the merits of the case and the merits of the profession, and not a bunch of outside stuff that lawyers can find to pick at.
Sure, got it.
The more complicated you make something, the more you give lawyers, and I can say this because I am one, something to pick at to distract attention from whatever the violation is.
Known across the state.
Commissioner Gallagher, this is Brian Prince. If I can add another thing, when you think about the administrative law judges that our staff is going before, it's a rotating group. So it's not the same administrative law judge. So
Okay.
that argument that confusion comes up the next time we get the newest
Okay.
administrative law judge, and the next time we get the newest administrative law judge. Oh, you're doing an orthotis case. Now, oh, what about this issue here? So that pool is mixed, and they're not just dealing with our cases, they're dealing with the plumbing board's cases, and they're dealing with the real estate commission's cases. So the complexity and just the
Sure.
volatility of that, it changes, so.
Okay, thanks.
One other thing I'd mention about using a single range of penalties per class. I would say that this is consistent with the agency's goals and action plan as stated in our most recent strategic plan. If you may recall, Agency Goal 3 relates to enforcement, and it relates to the targeted use of enforcement's resources. And there are certain action steps that are set out under that goal that the agency has committed itself to. And one of those action steps is to streamline procedural steps to ensure prompt investigation and resolution of complaints. And when we brought that concept to the table back when we were working on a strategic plan, this is one of the things we were talking about, the messiness that has come into play in some of the penalty matrix discussions.
Yeah, it's huge. Yeah, it's good. Thanks.
Another thing I'd like to mention to you that is different about the athletic trainers matrix as opposed to some of the previous ones is that standard of care violations are set out separately with actually the words standard of care in the heading. And this is a shorthand or a pointer for our staff. Any violation that's identified in the matrix as standard of care is a violation that we're going to need an expert witness to help us with during the investigation of the case.
And the advisory board members will serve in that capacity?
They are, yes. They are not the only ones who are possible to serve in that category, but they are the first group who we are inviting to come in and serve as expert witnesses for us. And we've actually issued invitations to about 25 of them, and we've gotten a pretty good response already.
And Commissioners, if I can add, again, Brian Francis, the advisory board's role is not as an advisory board, but it's the individual expertise of those members. So it's not going to come before the advisory board as an issue, but as a case comes up that has a standard of care provision, we may call on advisory board member X or advisory board member Y, here are the facts of the case, what's your expert judgment? So again, the role is not to the whole board, it's to individuals that have participated on the board that have that level of expertise. And then finally, I offer that at the last commission meeting, there was some discussion about what type of changes are we making in our intake process and our enforcement process that's different from the healthcare programs that we've inherited. This is part of that process. Christina's group has gone through the whole flow on the intake, on the investigative side, as well as the prosecution side, and we have made adjustments to the enforcement process to reflect that the standard of care cases will be a little bit different coming to the agency. And I just wanted to let you know that we followed up and we have followed through on that request at the last meeting.
The standard of care cases are, the reason we'll need an expert witness there is because the issues in this case will go beyond a simple determination of what the facts are. You're also going to have an interpretation of whether those facts reflect a violation of some standard that's applicable to the profession. An example is in Class C, there's a violation under standard of care, providing healthcare services outside the scope of practice of an athletic trainer. That outside the scope of practice is something that means something to an athletic trainer, to a person who's in that industry, but those words are not something that we can simply prove by facts. We have to have someone to interpret the facts that are in front of us to make that
So if
determination.
they were trying to be a counselor?
Right.
Or something like that?
Right.
Okay.
Right. We may also seek the use of an expert witness on cases that are not identified here as a standard of care, but those are the ones where, in talking with the advisory board, we determined that we're probably going to always need an expert witness. So that's why we have those headings set out separately.
And if the unique expertise is not on the advisory board, you're getting a recommendation from the board who's in the industry to use, or?
Yes. What we thought we would do is, after, with the first wave of invitations to serve as an expert witness, going to the advisory board members, if we don't get an adequate response there, or maybe in a couple of years' time, some of them stop wanting to do it anymore, we can also send invitations to people who are just in the industry. That might be recommendations from the advisory board. Another source of that information might be industry associations that are specific to that profession. And then also former members of the board, when it was actually an independent board over at DSHS, is another potential pool of those.
And again, Brian Francis, Christina had showed me probably about 6 months ago a document that they receive annually that has a list of expert witnesses that can be selected for the different industries, and that's another resource
Right.
that we may use in that process.
Yeah, that's another thing that lawyers get those in the mail all the time. It's a big directory, it looks like a phone book, and it's full of, I will be your expert for whatever the topic is. So that's another potential.
Is there a fee or stipend or something? I know not for the advisory board, but if you're grabbing someone from
We
the
are,
industry.
we are approaching it right now with the assumption that the members will serve on a voluntary basis, but that's definitely a question that we may have to confront. You know, if we need to go out to someone in the industry because advisory board members aren't available, or they might be conflicted out on a particular case because of their knowledge or acquaintance with the people involved, that is something that we may have to do at some point, is pay for the services of an expert.
And
We do
what's
have.
the order of magnitude of, I have no clue. I mean, what's the order of magnitude of what that kind of fee would be? Just,
We have experience with this from the air conditioning industry from some years back, before we had an air conditioning expert on our staff. And that was a while ago, I want to say 6 to 8 years ago. And we paid those folks in the, $2,000 to $3,000 for their services typically. In these industries, honestly, I don't know.
okay.
It'll be, what we have to pay to get an expert. So we'll have to kind of learn that as we're going along as well.
I guess is that gonna be in the event that we ever get to that point, gonna be a budget item for
Yeah,
us?
that's what I was going
It's going to be a cost that we'll have to absorb.
Oh, we have to absorb it, okay.
We will have to absorb it
Okay.
and look at it. And I think, like Christina said, we are coming at it from the standpoint of this first go-around, that we're going to use our advisory board members. And I don't want to use the word used inappropriately, but we're going to rely on them and their volunteerism. And keep in mind that these programs, there is a low level of complaints that have been involved in it. When we did the research for these programs, all 13 of them, there was 61 disciplinary actions between all 13 of them for a whole year. And keep in mind that all of those cases weren't standard of care cases. They were basic unlicensed activity cases, didn't have the registration. So it starts funneling down to very few cases, and very few of them are going to be standard of care, and we'll have to analyze those as they come forward.
So sounds manageable is what I'm hearing.
Yes.
It's manageable until it's not. And I think when we arrive at that point, we'll do the flex.
That's some wisdom for you, I
I
think.
think there's a cowboy hat down there. There's a cowboy hat. A little sweet.
So Commissioners, at this point, I can walk through the violations that are in each class, and we can talk about those, or I can simply open the floor and take any questions that you might have.
Is anybody interested in having each individual one? I think you've had a chance to review it, so.
Just keep us informed from this. There's a lot of flow in the medical side on this.
Right.
I know there's gonna be a curve, it's gonna be steep.
Yep.
Right.
So,
Ultimately, we are requesting that you vote to approve this new matrix to be included in our enforcement plan.
No other question, I'll move to approve it.
I second it.
we have a motion and a second to approve the penalty matrix for the athletic trainers. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Was there a date, or is it gonna be immediate?
This is not a rule, it's simply a policy of the agency, so it will be
So it'll be
published in the
read.
Texas Register and then placed on our website. There's not a need for an effective date.
Okay.
It's effective with your approval.
Christina,
Perfect.
I've just, I've been to a couple of advisory board meetings, I see all the work that takes place there, and so I talked to Brian about this a couple of days ago. I don't know how we get word down to the staff that we appreciate all the hard work. I mean, it all culminates in a meeting, but we don't see the hours and hours and the frustration and the time that goes into these things. And so, just want to let your people know that I think appreciate all the effort and time that y'all put into something like this. And it's so funny, you just look at the matrix and go, it's just a matrix. But there's a lot that goes into that, and you're hamstrung by what we tell you to do and what the legislature tells you to do. And so,
And you managed to make it work.
so please let your people know and you how much we appreciate all the effort and the time that goes into something like this.
Thank you, sir.
Great job.
Thank
Yeah,
you.
Appreciate it.
Thank you.
Let's move on to item R, our staff reports. I was gonna try to think of a very dignified title for you, but I couldn't think of anything. So, I would also make note.
I think
that,
that's accurate.
make note that, this is the first meeting for Carla and Nick. So I'm sure Brian's gonna say something. I probably stole his thunder.
That's all right, that's all right.
So,
I recognize Zeus chair. I understand where the lightning bolts are.
Welcome, and I tell you what, we are fortunate to have both Carla and Nick on our staff. They have done an outstanding job so far to date. So, of course, we're a month into it, but we'll see.
It's all downhill from here.
Yeah, honeymoon's over with me.
Mr. Chairman, Commission members, I'm Brian Francis, Executive Director of TDLR, and I would like to start off introducing the team, the trio. We've got Carla here as the Deputy Executive Director and Nick as our Chief of Staff of Strategic Communications and Customer Service. And we are learning each other, and it is really working well. We're jiving and gelling perfectly. We bring a balance. Nick is the tall, handsome, quiet type. Carla is the fiery brand over here. I bring my little style to it. And so every Tuesday, the three of us have what we call Tuesday Talks. And part of it is just understanding each other, but also understanding the issues. And in those discussions, we let it all hang out. And we are really, really getting up to speed on it. I think both of them are leaving a stamp and an impression on the staff that they know what they're doing, that they're here to help the staff be successful. They're listening, which is so important, and I've talked about that to them, and they are just fantastic at just listening before they're trying to make changes. They're trying to understand before they present ideas, and that's been very effective. But I'd like for Carla to say a few things, and then Nick to say a few things.
Thank you, Brian. Carla James, Deputy Executive Director. I just want to thank Brian and the Commission for the opportunity to work at such a great agency. I have been lucky enough to know Brian for a number of years. We've sat in many, many budget hearings together. I've said before, licensing came before security, so I got to sit through all the licensing because I was last in the alphabet. But it's given me a great grounding for what the agency's like and how it works, and it felt like home day one. So just feel very lucky to be here. Our staff is pretty amazing, and I think I'm really downplaying that. We've got a group of folks that not only are they hard workers, but they really enjoy being here, and so the culture of this agency is something that I think a lot of people are envious of. So very happy to be here, and as Brian said, I am taking my time. I'm accustomed to going into organizations where things need fixing. Things don't need fixing here, so it's a nice dynamic to sit back and absorb it all and see where I can make a few enhancements here and there, but we're not broken, so I don't have to come in guns blazing this time, which is, as I age, is a nice, it's a nice change, so I'm just appreciative of the opportunity to serve in this capacity for this agency.
Welcome aboard.
Thank you.
Mr. Chairman and members, thank you for this opportunity as well. It's a blessing to be here and work with such great people. As Carla mentioned, our staff are incredible. They're very experienced, and they share a passion for what they do. They come to work every day very proud to serve the people of Texas, as we all do. And thank you for this opportunity, and look forward to working with you closer and getting to know you all a lot better. Thank you very much.
Thank you, guys.
So you can tell that Nick is into tweeting. He's just 140 characters when he talks, just right to the point, the economy of words, all that good stuff.
His background kind of lends to that.
It
Direct
does.
message.
It's right there.
Short,
It's
sweet,
right there.
but get it all in there.
It's right there. Commissioners, I just want to give you a quick overview on a few things that are going on. I want to remind you that every Friday, you'll be receiving that bill tracking information that's in front of you. I don't want to go to the minutia of it here, but if there's any bill that interests you, that you have a question about, call me, Nick, or Carla. We'll walk you through where we are in our discussions and the dynamics of those particular bills. Our legislative team is amazing. They are hardworking. We meet every Monday morning for a legislative briefing, and then we meet every Thursday afternoon for a briefing to go through and kind of figure out what we've done, what we need to do, and how we're moving forward with all the stuff that's flowing in. It's exciting It's the work that's out in front. But I would want to just remind you that sometimes the legislative process seems to be the only thing we're doing. But the truth is, our agency is what makes it successful. It's the folks that are issuing the licenses, that are closing the complaints, our GC staff, whether they're answering the phones, paying the bills for us, the people who are doing the inspections, the investigations, the prosecutions. They're the ones that make TDLR work. And sometimes, the legislative group, we're cranking it out and we're doing all this high-level stuff, but they're the agency. They're the ones that get it done every day and that really build our reputation. And we're so fortunate to have all of them here, and they work so hard for us and so committed to making the agency successful. I'd also like to bring you up to speed. I sent you some information on the two bills that were filed for the budget on the House and Senate side. This is going to be a tough session, budget-wise. The state identified about an $8 billion shortfall in terms of the budget, the biennial revenue estimate. Agencies have still been called on to do the 4% reduction, which you voted in the LAR a while back in August. It's going to be a tight budget session. We feel good about where we are. We recognize that the legislature is hearing our story about our needs in terms of the second phase for the transition. We're going to continue to work with them. We're going to modify and tweak our appropriations request, obviously, to reflect the changes. Whether it's in regard to the biennial shortfall, whether it's in regard to our leadership in the governor's office, recognizing that we've got to focus and treat government the way people are treating their personal lives. We have to tighten things up. We have to be more efficient. We have to be more innovative in the way that we do business. We'll continue to keep you apprised of what's happening there. Next Friday, we have our document that's due for budget for the House Appropriations Committee, and then the Friday after that, we have our document that's due to the Senate Finance Committee, and then Carla and I will be testifying before the Senate Finance Committee on the 14th. So that's just moving, and then we anticipate that, once appointments are made on the House side, that those budget hearings will be scheduled. You'll get the updates just like you do through our In the Loop and Under the Dome that Jeff Copus does a fantastic job of providing to you guys all the time. So things are moving quickly, and we're trying to make sure that we're staying on top of things, making sure that we're getting it done. I'd also bring up the last executive briefing document. A couple of kudos. Commissioner Collier came out to the forum in Houston. The staff really appreciated your presence there. It meant a lot to see you there, and we appreciate that. And I know that Commissioner Butler will be at the meeting on Monday for the licensed breeder program. Also want to bring you up to speed on that the survey has been completed. It will be discussed and presented to the advisory board on Monday, and we're continuing to have the discussions about the cages and the stacking and those sort of things. But now we have a little bit of data to speak from, and I think that's going to help us continue the conversation and to move forward in that direction. Last thing I wanted to talk about was, that's it. That's all I want to bring up. And I'm available to answer any questions if you have any.
Thank you so much, Brian.
Okay.
And again, that's a lot of work, I just want to let your folks know that we appreciate the work they do. And there's so many unseen heroes in this process.
Absolutely.
From our perspective. And so I just want to shout out to all our employees, and we really do appreciate everything that you do. I know it's hard work, and with Christina up here and Mr. Sharp stealing all the oxygen in the room.
He was late. He had to grab it.
Those are the ones that we interact with, and we get to tell you thank you when you come up here and do your hard work. But there's so many in the agency that we don't get to meet and chat with. That we just want to let y'all know that we do appreciate the hard work. We know what goes into it, and so thank you for that.
And if I may, Commissioner Butler, Brian, one just quick, and I'll send the ones that I want you guys to track for me, or
Yes,
send me the
ma'am.
information. The House Bill 925 on the booting, I know that was a post-conversation. I can't think of the gentleman's name right now, forgive me.
Mr. Confer.
Yeah, thank you, yeah. So from the towing advisory board, so if you can kind of keep me abreast of
Absolutely.
that one.
And Commissioner Collier, keep in mind that is one of the strategic initiatives that we're moving
Sure.
forward with that would deregulate the statewide requirement for booting but still allow municipalities and private and public universities to be able to boot it if they choose to engage in that.
Okay.
And we'll definitely keep you apprised of the movement.
Okay, all right, I appreciate that. And obviously, anything that lives and breathes close to the hub site, I want to stay close to that.
There was just a bill filed yesterday that deals specifically with that, and we'll make
Okay.
sure.
What was that number on that one?
Let me find it for you as we're talking. The other thing I forgot to mention, thank you, Carla, for reminding me. I've got the honor of being invited to the Governor's State of the State on Tuesday.
Good.
And so I promised to get my beard shaped and represent the agency well, but it's the first time I've had an opportunity to be a part of that, and I'm really humbled by that opportunity, so.
That's good.
Hopefully I'll get a picture with some famous people.
I'll retweet it.
That's right, that's exactly right.
Hey, Brian, the chief is going to be presenting, Chief Justice is going to be presenting to the joint session
You gonna be there?
legislature next week. I think, I'm not sure what the date is, but one of the speak-tos is going to be the shared services and best practices that we implemented at the Judicial Council,
Okay.
which I'd like to make sure if you get a chance, because I know the practice, especially during budget cutting, some people take a chainsaw to surgery. And I think it's
Absolutely.
important that, especially our biggest resource are our people. And we gotta guard them with, I think, the utmost care. And so, in that process, I wanna make sure that, there's opportunities that are fully taken advantage of in the shared service approach. So, if we can speak about that, that'd be great.
Absolutely. Commissioner Collier, it's HB 1281.
1281.
Again, that was just filed yesterday.
And before we transition, Chairman, if I may, I do want to thank you, Brian, and your staff for incorporating the safety, information for the video as well. I mean, most folks, probably know. I mean, I kind of cut my teeth in oil and gas, and of course, the family business was auto paint and body and repair. So safety's always, first thing. And so I appreciate that as we, from a TDLR standpoint, invite folks into our home, we have to make sure that they're safe,
Agreed.
first and foremost. So,
I
so
think it's one of the most positive statements that an agency and organization can say about how they care about their folks.
Mhm.
Is that we want to keep you safe, even when they're not aware of it. We're looking to keep you safe. And again, when you're inviting guests into your home,
Mhm.
you want them to feel safe while they're present there.
So, thanks for
Absolutely.
that. Mhm.
And for the commissioners that haven't noticed, but there is a video that's running while we're kind of getting ready. But also, as you go out, during the sign-up, there's actually a pamphlet there that I would encourage the commissioners to pick up. I received one yesterday, but it's kind of talking about safety and stuff, so I appreciate that. Yeah, we got the 2 chairs that we needed, so I appreciate Commissioner Collier for pointing that out to us. It's amazing how when you bring new commissioners on, they kind of see things that we've kind of been either blinded to, or we just kind of just a standard part of what we do. So it's good to have fresh eyes, so thank you very much.
She has a way of gently nudging you consistently and persistently to where you become better. And that's what we want.
So, okay, what else?
Mr. Chairman, we are ready to go to the appointments.
Okay, so we're not having anybody, well, good, okay. Let's move on to item S. Commissioners, before you have a list of appointments. You received a copy, I believe, in your email, but there are a couple of things we want to point out was in the auctioneer, we had, I believe, Rick Stroud. Well, let me just kind of go through these. For the Architectural Barriers Advisory Program is to appoint Francis Robertson out of Leander. And the Auctioneer Advisory Board is to appoint Rick Stroud. Out of the Board of Boiler Rules, appoint Brian Mallon out of Santa Fe, Texas, and Alan Kripe out of Temple, Texas. Dietitians Advisory Board is to appoint Grace White out of Watauga, Texas. Speech Language Pathologist and Audiologist Advisory Board to appoint Kimberly Ringer out of Pflugerville. The Water Well Drillers Advisory Council is to reappoint Lonnie Ball as the presiding officer, Billy Lang as the vice presiding officer, Ray Reed as the secretary, and Raymond Wisenot as the, also on the board. You have their expiration dates there also. So I would ask, the only thing that I would say is changed, that there was a couple of dates that we fixed that the infamous Tamla Fletcher caught. So she's there. So we noticed there were some errors of the dates. So I'll take full responsibility, and Polly told her to put those dates on, so she corrected my errors. So, but I would ask that you go ahead and approve these. You also have the applications with you, which I believe you received ahead of time.
Do we need to make a motion?
Yes, please.
I so move that we approve the advisory committee appointments.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed? Thank you, Commissioners. Let's go into item T, which is our advisory board report. Susan, come forward.
Good morning,
Good
Chairman
morning.
and Commissioners. I'm Susan Sanford with the Office of Strategic Communications. Chairman, I'd like to thank you for the heart palpitations this morning as you put the metal to the pedal and went from F to P so quickly. I went, oh my Lord, I am going to get up there this morning.
You are.
We can wait till 1 if you want.
So, we have a written report for you, but I also have two additions that I would like to update you on. The first one was just a minute. Last Wednesday, January 20th, the orthotist and the prosthetist met, and the highlight of the meeting was that they did recommend the approval of the penalty matrix for their program. And I
We'll have
imagine
that
that
come
will be
before us.
presented next commission meeting. And then just this past, you see today's Friday, past Wednesday, I was with the midwives. And they also passed the penalty matrix, and it will be on your agenda next month, I'm assuming. So are there any questions? I'd be happy to answer anything you'd like to pose to me.
Any questions for Susan? Commissioners, you all have, thank you, Susan, I appreciate it. You all have
Thank you.
been appointed as a liaison for some of these advisory boards. If you're able to make it in town, that's great, but if nothing else, at the minimum, maybe just jump online and watch it, because most of them are being broadcast online, so, thank you very much.
Thank you.
Thanks.
Let's go to item U, public comment. If there's anyone wishing to address the commission at this point in time, you have 3 minutes to address the commission. There being none come forward, I'll move on to item V. Commissioners, we have a scheduled meeting date of March the 1st. I think I earlier stated March the 8th, but it's actually March the 1st, and another one dated April the 5th. I would suggest at this point in time that we go ahead and schedule our meetings for May the 17th and also June the 28th. That gets us out there to about half a year.
Hey, was it March
It'd be
1st?
March 1, April 5, suggested, those are the scheduled dates at this point in time. Okay, so those are scheduled. Suggested May 17 and June 28. I would ask that you look at your calendars for the May 17th, June 28th dates to make sure there's no conflict. Another thing I do want to also ask the commissioners, we normally meet on Wednesday. That's kind of been the set that we've been at. I've had several comments from employees asking me why we had a meeting on Friday, because I had to get dressed up. So, yeah, I see shaking heads from staff. But if there's a particular day of the week that works better for commissioners, I would ask that you submit that to Kay and Brian, and just let them know, and we'll evaluate that, and we may end up moving it, but at this point in time, I'm inclined to leave it on Wednesday unless we get kind of a consensus from the commissioners to move it to a different day of the week. So I'm not opposed to it, but it's just something that I want to be able to bring out to the commissioners, and I may try to do it annually to see if we need to change it at any point in time. So, but as right now, they are Wednesdays. So, but yeah, I mean, if there's a particular day that you like, then just send it to Kay and maybe copy Brian in on it so he's aware of it too. And then they can bring it to me and we'll kind of evaluate it at that point in time. Sound great? All right, there being no further business.
We do have a quick, I know, are we looking to wrap at 10?
Are you
15?
wanting to make a public comment? You had that opportunity.
Yeah, 3 minutes.
Collier.
3 minutes.
Brad, 3 minutes. Go right ahead, I'm
No,
sorry.
well, it was just a couple of questions on some of the reports
no, go right ahead.
that we had. Give me an idea, Brian, what we do with the, because I saw where there's observations for the human trafficking.
Yes.
What do we do with that data?
Thank you for bringing it up. It's a really passionate issue for our agency. 2 of our programs have commerce in that area, and it's the cosmetology program that could be a ground for that, particularly in some of the salons. So the training that we have done so far is that we have trained our investigators and our inspectors. We brought Kirsta, who is with the Attorney General's office, to just bring about the awareness. The mechanism is our inspectors and investigators are not the police in saying there is human trafficking, but if they see signs that maybe think it could be there, they now have a mechanism just to simply make the phone call to the 1-800 number, and then that human trafficking task force, whether it's the local police department, the sheriff's department, then they take it and they run with it. So it's really about awareness. I attended the press conference 2 weeks ago from the Attorney General's office regarding the human trafficking efforts that are taking place. January is Human Trafficking Awareness Month. So the agency has a presence there. A massage program is going to be one where we're going to be knee-deep in it. And with our agency taking the role and really moving forward with inspections, which for whatever reason has not been done in the Department of State Health Services, I think it's resources and that sort of thing, we're going to see it. We're going to be coming face-to-face with it. You'll recall that in our exceptional items, which is now rolled into our baseline, which we're excited about, for the Phase 2 transfer, we included a position for a human trafficking coordinator for our agency, one that will be a liaison to the governor's task force on this issue, as well as working with the OAG's office, but more importantly, working with those local jurisdictions. And the key, again, is awareness. Our staff being able to recognize those signs and then knowing the next step to take. How do we get that information out to the folks that are going to work on it? The training of our investigators and our prosecutors and inspectors to recognize that a person who is being trafficked may not be engaging in unlicensed activity. They're being trafficked. And so it's a different way, a different nuance of looking at those moments. It's not going to be black and white. And so the agency is really redoubling our efforts. Jennifer Harless, Colleen Tron, they have been out in the front for our agency on this. But now it's going to be something that's going to become core to what we do. We also are hearing that there may be some legislation filed that will require an hour in the area of human trafficking for some of our areas of licensee, whether it's the cosmetologist making you aware. There may be notices like you see in the shops that say, oh, by the way, this place is licensed, and by the way, if you see human trafficking here, here's that 1-800 number. So really on this side, for our agency and really for the public, it's about just being aware of the signs and feeling comfortable enough just to make a phone call. And you're not engaged any more than that, but that could be the beginning of it, of identifying.
Okay, and customer service is, heads up and aware in case they get phone calls.
Customer service is aware, and again, it's that 1-800 number to that toll-free line. That's really the key.
Okay.
There is a mechanism set up for folks to go and go look at it. We just simply have to be a conduit by which those items are reported.
Okay. Right. And my last question, as you're wrapping, putting your jacket on and stuff.
I'm trying to wrap.
What's the timing of completing the procedures for the enforcement division for protecting, the data?
It's ongoing.
Okay.
You'll recall that we've expanded our efforts and resources in the area of records management.
Right.
And Alric and Sheila are doing phenomenal work. I had an update from them a week and a half ago about all the areas that they're working on, and one of the threshold areas is enforcement, but it's not just that. Every record that comes into our agency is precious because there's the potential for personally identifiable information in there. So they are taking more of a global strategic approach to all of our documents, but that is part and parcel of it. Also, when you look at our webpage, we've updated to, again, if a person's filing a complaint, to have information saying, do not send information about X, Y, and Z that's specific to it. So we've already taken some efforts to help help the folks understand how to interact with us, with that very sensitive information.
Okay, super, thanks.
Yes, sir.
I failed to note the retreat that was currently scheduled for today and tomorrow. We had to move because of just some issues that took place. We're now looking at that probably taking place in around July.
July, yes, sir.
So as we begin to start kind of narrowing down those dates, I'll make sure that that Kay and Brian keep you aware of that so that you kind of know which dates we're looking at. But right now, we're looking at probably sometime in July, kind of having the, excuse me, the commission retreat at this point in time. So there being no further business come before us unless commissioners have another question. If not, then I will consider this meeting adjourned.